Perfect. It looks like everybody's on, which is great. Good morning, everyone that's on so far. We're just going to give it a minute or so because there are still people joining as we speak before we get underway. So if you just bear with us, then we'll kick off as planned. In the meantime, I'll just get the slides up ready for you all. Right, well, I think we've got the majority seem to be on now, so we'll get started as planned. So good morning, a very warm welcome to all of you, and thank you for joining us this morning on our webinar. The aim of this morning is really to outline some of the headlines around Labour's making or plan to make work pay. I've got three lovely experts that are joining on the panel this morning that are going to be sharing their wisdom with you. We've got from our very own office here at Quest, Lisa Jones, who is a senior HR consultant here. We're also joined by Nick Wilson from Robinson Ralph, our resident employment law expert, and also Graham Morrison from Law and Accountancy, who's going to be talking to us about all things financial this morning. So thank the three of you, first of all, for joining us. Just to explain a little bit about the format of today, you'll see hopefully everybody's cameras and mics, other than the presenters, should be disabled. Please do keep them that way if that isn't the case. There is the ability to add questions during the course of the webinar. So you should see a Q&A tab on your screen. Please just drop any questions in there and we will come to those at the section at the end, assuming we've got time to be able to run through any questions. And obviously those that might have been answered, we will skip through. If you do pop a question on there and for any reason we don't get time to get to it today, we will follow up after the webinar to answer that for you. So just looking at our agenda this morning, we're going to kick off first and foremost with looking at employment law changes for this year, those that have already happened and those that are pending and shortly to come. We're then going to look at some of the key headlines of the plan to make work pay. Please bear in mind, Labour's guidance is pages and pages long. So we've tried to pull out some of the key highlights that are going to affect most businesses. And of course, it is on the caveat that all of these are proposed changes. There is obviously time that will be taken to see how these come to fruition, but hopefully it will help you all plan in advance of that. And then we're also going to look at, with the change of government, what financial or taxation considerations we need to be thinking about as business owners. And as I say, we'll move on to Q&A. So in the first instance, I'm going to introduce Nick Wilson. He's a partner at Robinson Ralph. We've worked with Nick for many, many years, and he is definitely our go-to for all things employment law. So Nick, I'm going to mute myself and hand over to you, and I'll let you walk through this year's employment law changes.
Thank you, Sarah. It's good to be here. Good morning, everyone. I think everyone thinks that employment law is always changing, but I think mostly that's not because of new employment laws or regulations. It's more because of social and economic conditions changing and then applying existing employment laws to those changing social and economic conditions. But this year, there's actually quite a lot of new legislation come into force, and that's in addition to what the Labour government is proposing to bring in shortly. So I'm going to do a bit of a whistle-stop tour through a lot of the legislation that's come in. I think I've covered most of those things, but in particular, I've focused on stuff that we've been advising our clients on most recently as well, because, you know, in the day-to-day world of employment law, all kinds of issues can come up, but obviously you do need to keep abreast of recent legislation. And we find that the normal queries that we get, certainly recently, have involved just looking at some of these new legislation and regulations which have come in. So the first one I'm looking at is flexible working. So early this year, the new flexible working amendment regulations came in, and previously the right to request flexible working arrangements. You're entitled to make one request every 12 months. And before that, you needed 26 weeks service before you can make such a request. But as of the 6th of April this year, those regulations have changed. So now the right to request flexible working arrangements applies from day one of employment. In addition, the employee can make 2 requests during a 12-month period and not just one. So obviously employers have to be prepared for that. And more fundamentally, though, the timescale for the employer responding to any request has been reduced to 2 months rather than 3. So those are some of the headlines around flexible working. And I think when these regulations came in, people were thinking, oh, we're going to get a whole raft of requests here, particularly as it's a day one right. But I think given the shift to more flexible working arrangements anyway, as a result of COVID and the pandemic, our experience is that employers haven't really seen a significant uptake, because I think most employers anyway offer more flexible working arrangements such as hybrid arrangements now. But where challenges do come in is obviously employers' perception of a request for flexible working arrangements, which an employee may make very early on in the employment and might actually require some rejigging of working arrangements, which can obviously be a bit of a challenge at times. So that's something to watch out for. Obviously, it's a day one right, and you can make 2 requests now in that first 12-month, any 12-month period. The next set of regulations which have come in this year, again as of the 6th of April, we've got the carers leave regulations. So these apply to employees who provide care to dependents who need obviously long-term care. The regulations define a dependent as being a spouse, civil partner, child, or parent of the employee. And that person must either live in the same household, or it would be reasonable to give care to that person if they don't live there. So that obviously means that you can't be giving care to a lodger, a living employee, or somebody like that. Significantly, this is another day one right, so it begins as soon as the employment begins. And the right is to 5 working days leave during any 12-month period. The employee must give a minimum of 3 months' notice or twice the amount of the leave to be taken. Now, significantly, this leave is actually unpaid, which again, it might mean there's not a massive uptake on this kind of leave. But we've had a few queries about this, about employers. They're faced with employees who might want to take leave on a relatively urgent or emergency basis, and obviously you've got things like emergency leave to care for dependents, but this is a slightly different thing, where people are envisaging that they might have to take some time off to care for people who might have a disability. They might have might be going for an operation in hospital, which means they're going to be off sick for a period of 3 months or more. So there's obviously quite a few scenarios where this kind of leave can be taken. Now, given that the notice requirements are fairly short, the employer can still postpone the leave for a period of 1 month, but obviously they'll need to take into account various other things, such as the reason why the employee is asking for the leave. If they're going to be caring for a disabled person, does that put the employee in a bit of a difficult position? Are they not going to be able to take the leave and things like that? So that's carers leave regulations. The next set of regulations I'm looking at is the extension to redundancy protection. So actually, it was under the Tory government that the notion of extending redundancy protection for people taking maternity leave was first mooted, and it came in again as of the early this year. And the previous the current regulations, under Regulation 10 of the Maternity and Parental Leave Regulations 1999, an employee who's on maternity leave, if the employer cannot continue to employ them in the role that they're currently employed in under their contract of employment for reason of redundancy, that individual should be offered suitable alternative employment if it exists. So effectively, the purpose of that regulation is that if you're on maternity leave and you're potentially redundant, you get first dibs any suitable alternative employment. Now, these new regulations have extended that protection. So if your post is redundant during a period of ordinary or additional maternity leave, then again, the employer must offer any suitable alternative employment to you. This, but that right applies not just during the period of maternity leave, but also from the point that the employee notifies the employer of the pregnancy. That's obviously quite a long period of time, and it includes the pregnancy itself and not just maternity, but also during the 18 months following the return to work from maternity leave, adoption leave, or shared parental leave. So we get the odd query from clients who, they might be undertaking redundancies, and there's an employee who's on maternity leave, for example, and obviously the question is, can they make that person redundant? Often within a number or group of redundancies, it's not that person individually, but if that person's role is just a standalone and they're potentially redundant, then obviously that provides some challenges. But now with the extension of this protection for such a long period of time, employers have to get their heads around the fact that even after the return from maternity leave, people do have a significant period of protection now, whereby if their role is redundant, they're not just going to be lumped in with the rest of any affected employees who are potentially redundant. They effectively get first dibs to any suitable alternative employment. We've had a couple of clients recently looking at making redundancy where this issue has arisen, and fortunately there is suitable alternative employment which can be given. But obviously, if you give that suitable alternative employment to another employee who's not protected under these regulations, then the employer is going to face difficulties because they'll be in breach of these new regulations. The next change to law is on the topic of TUPE, which I think for most people is one of their favourite legal picks. And for those who don't know about TUPE, this is the Transfer of Undertaking and Protection of Employment regulations, which apply essentially where one business takes over another, or one contract takes over another contract in a contracting out situation. It could apply in other situations like the purchase of assets, goodwill, or even taking over a license for a building. But ultimately, the purpose of TUPE is to protect the employment of those staff who are employed in one business when that undertaking or business transfers to another organisation. Now, TUPE is quite a difficult piece of legislation because it's very procedural, and it does actually place some quite onerous requirements on employers on both sides, whether that be a seller and a buyer, or however the transaction is worked out. And one of the main challenges for TUPE is that where there is a TUPE transfer, the outgoing employer is required to inform and consult with appointed representatives of the affected employees. So affected employees is anybody who's affected by the transfer. So that could be people who will transfer from one employer to another. It could be staff who might not transfer, but their roles are affected as a result of other people transferring. And it might also include staff who are already with the business that's going to be taking on other staff if their roles are also affected. So that doesn't sound too onerous, but the real problem arises in that the outgoing employer has to inform and consult with appointed representatives. Now, in most workplaces, if there's no union presence or workplace body representing staff, that means the employer is going to have to find a way of ensuring that there are representatives appointed, and that can only really be done by facilitating an election of representatives by staff, which is not a particularly quick process. And getting staff to engage in that is quite difficult anyway, because at the same time as saying to them, you need to appoint some representatives and you need to vote for them, staff also have often quite legitimate concerns about what this means for their employment. They're wrestling with getting people to represent them with the fact that they're going to be employed by a different business or engaged by a different company at some time in the future. So the change to TUPE is this. As of the 1st of July this year, employers can now consult directly with staff rather than having to elect representatives where the organisation has fewer than 50 employees or with fewer than 10 employees transferring, and that's irrespective of the size of the organisation. So until recently, the only way that an employee didn't have to consult directly with representatives was if it was a small business, a micro business with less than 10 employees. But then you'd have situations where a business might have, say 20 employees, but 5 were transferring across, and they still have to elect representatives and things like that. So this is actually a welcome change, and it makes it easier for employers now to consult directly with the employees, which in my experience often is a better way of consulting with staff and getting their questions answered. So that's TUPE. The next change that came in this year relates to the issue of fire and rehire, which in an employment law context is going to arise where an employer is looking to change terms and conditions of employment, but then the contracts of employment, for example, don't allow them to do that. And what the employer has to do is go to the staff and say, we want to change your terms and conditions of employment. We're seeking your agreement to that. And ultimately, if there is no agreement from staff, then there is what we call the nuclear option, which is employers terminating the current contract of employment with notice and then immediately offering re-engagement on the new terms that the employer is proposing. Now, I say that's a nuclear option because it's not often used, and it's been widely criticised by the Labour government and the trade union for many years because many people view this as being a way that employers can just change the terms and conditions. It amounts to something of a threat. If people don't agree to it, they might get dismissed. They're immediately offered new terms. What the employer has to do in those situations, because that does amount to a dismissal for unfair dismissal purposes, what the employer has to do is make sure there's a sound business reason for that. Now, interestingly, it was the Tory government that earlier this year introduced a new statutory code of practice on dismissal and re-engagement. And the statutory code of practice applies where the employer is contemplating making changes to terms and conditions, as I just referred to, and envisages that if there's no agreement, they may dismiss and re-engage on new terms. Now, the first point to note is that the statutory code isn't legally binding, but it will be taken into account by an employment tribunal if there's any claims that the tribunal hears, such as unfair dismissal, where the code of practice might apply. And there's a few key points to the code of practice which weren't actually part of law before. So the first is that the aim of the code of practice to ensure that meaningful consultation takes place between employer and employee. And if there isn't initially any agreement between staff and the employer, then the employer should re-examine its business strategy and then take into account whether there's any potential negative effects in proceeding with the proposed termination of employment and then re-engagement. Where an employer does terminate and offer re-engagement, all they were previously required to do was to terminate the contract with the notice that was applicable under the contract of employment. What the code of practice suggests is that not only does that apply, but there should be sufficient notice to allow the staff to make whatever arrangements they might have to do as a result of their terms and conditions changing. So, for example, if you have staff with childcare arrangements and a relatively short notice period, that notice period might not give them enough time to make alternative childcare arrangements if the new terms and conditions mean that they have to change their working hours. It might involve additional travelling, that kind of thing. So employers also need to look at whether or not a longer notice period is required than simply what's offered under the contract of employment. The code of practice also makes clear that this practice of fire and rehire shouldn't be used as a threat to try and get staff to change their contracts. I'm not sure I've come across that in practice. I think, as I described it, it's a nuclear option, and I think most employers don't get that far. There's some agreement reached before the employee needs to terminate the employment, or staff just simply leave. They find another job and then just leave it at that. So it still underlines the point, though, that the threat of fire and rehire, it shouldn't be an empty threat. This is something that the employer should think that they're going to see through if absolutely necessary. And that, of course, involves having a sound business reason for making these changes. The other significant point here is that the code of practice requires the employer to involve ACAS the process, although it's not clear as to what extent ACAS should be involved, which is not particularly helpful. But for those of you who might have used ACAS in the past, they can sometimes be useful in terms of mediation or getting parties together just to discuss the issues. And I act mostly for employers, so depending on the conciliator that you might get, sometimes it is useful to have a conciliator who sets out the pros and cons to employees or employee reps. And sometimes I can see how it might be useful in this case if, for example, the employee does have a sound business reason for this. And then it's just a difficult task of trying to convey that to employees or their representatives. So if there's a breach of the statutory code of practice, then that doesn't give rise to any kind of standalone claim in the employment tribunal. But what an employment tribunal will do is they will take the code of practice into account when deciding whether on the level of compensation that's awarded. So if somebody brings a claim for unfair dismissal, for example, arising out of a change of terms and conditions, and the tribunal finds that the code of practice hasn't been followed, then they can award an uplift of apply an uplift of up to 25% to any tribunal award to reflect the scope of any potential breach of the code of practice. So we do actually have a fair amount of instructions on fire and rehire. So we'll see how this plays out. I think most employers tend to be very cautious when doing this anyway. So we don't see many that are trying to cut corners, but it'd be interesting to see whether there's any significant increase in this issue being raised in the employment tribunal. The last thing to know, seeing we're talking about Labour governments today, is that the Labour government has suggested that this code of practice is actually inadequate. So I'm expecting that at some point in the future, and this was obviously part of their plans to make Labour pay, to make work pay anyway, that they might either all the code of practice or make it much more stringent. But obviously that's something that we're still to see. The next thing that we're looking at is actually some legislation which is not yet coming in, but will be doing so as of the 26th of October, so next month. And this is the Worker Protection Amendment of Equality 2010 Act. But obviously, harassment at work is a real big issue now, as it should be. And again, this was something that that was mooted during the Tory government, but something which obviously the Labour government is looking at as part of their plans for reform. But the effect of this act is to amend or apply a new section 40A of the Equality Act 2010, which says that the employer must take reasonable steps to prevent sexual harassment of employees in the course of their employment. Now, again, we don't have any real assistance in determining what reasonable steps to prevent sexual harassment might be, but I've given some thought to how employers might look at these things and put in place measures to try and avoid sexual harassment in the workplace. I think the key point to remember here is that it's not just sexual harassment by the employer or by the employer's employees against their employees. It also covers third parties. So if your employees are working with third parties or seconded to a third party, for example, and they suffer harassment there, then these regulations will also apply. So in terms of what reasonable steps might be, you might look at things like anti-harassment policies, which I think most employers will probably have in place anyway. Staff training, which is key. It's okay having policies in place, but employers must demonstrate that staff are being trained on these policies. Obviously, making sure that staff are aware that there's a zero tolerance approach to things like sexual harassment or indeed any kind of harassment at work. Encouraging staff to report sexual harassment, obviously, is a cultural issue, but if people know that they are able to report such things, then it may well have the effect of minimising the risk of these things happening anyway. Investigating allegations of sexual harassment. We do come across cases where employers, when faced with allegations of sexual harassment, on any kind of level, just don't investigate properly. And the failure to investigate will then lead to, potentially being an issue in an employment tribunal claim. So the employer is not only stuck with an employee who may have actually sexually harassed somebody else, but the employer's inaction then means that any tribunal award might be more significant. The employer might want to carry out things like risk assessments. What is there any likelihood of sexual harassment? Because it depends on the scope of the work that an individual is doing. The tribunal cases tend to involve things like dinners or lunches where there's lots of alcohol, perhaps a male-dominated audience, and female waiting staff. It all sounds a bit stereotypical, but that's actually what has happened in practice and what the kind of cases that tribunals have to consider. And I think these new regulations do go to the core of those kind of situations. If you're a bigger employer, you might want to think about consulting with unions and workplace representatives. You might have things like workplace champions, people, members of staff who other staff can go to talk about these issues or to report allegations of sexual harassment without the difficult having to go to a line manager, for example, or something like that, which sometimes is a reason why these things go unreported. The employer must monitor complaints, though. They must be seen to be acting on complaints and seeing that they are dealt with properly. Also, the employer needs to make sure that there are outcomes to these complaints as well. So monitoring how these matters are dealt with, making sure there's an outcome, and if there has been sexual harassment, dealing with that properly. We do get the odd case where there's been an allegation of sexual harassment, and then the perpetrator of the harassment remains in employment, for example, and even working in the same place as the person that made the complaint, which is mind-boggling at times. Now, if there's a breach of these regulations, again, it doesn't give rise to a standalone claim, but what it does do is that if an employee brings a tribunal claim and is successful, the tribunal needs to award compensation in respect of the harassment, and the tribunal finds that the employee didn't take reasonable steps to prevent harassment, then they can apply an uplift of up to 25% to any award. And if you look at the compensation of injured feelings bands of compensation, then it is possible that these kind of awards will be in 5 figures up to, they go up 50, 60k in the absolute worst of circumstances. So if you add another 25% on, it can be very expensive. Now, just coming back to the Labour government, whilst obviously there's no issue with these regulations themselves, one of the issues that the Labour government has is that the regulations just require the employer to take reasonable steps. But what Labour wanted was the employer must take all reasonable steps. And I think we may see some movement on that. There might be a change to the Act as it currently is, if Labour actually finds some time to deal with that, because obviously we've got a lot on their plate at the moment. So it's a bit of a whistle-stop tour, a run through the legislation which is coming this year. And obviously, Lisa and Sarah are going to deal now with the legislation which is proposed and which we're expecting to see shortly.
That's great, Nick. Thank you very much. So what we're going to do now is just work through some of the key headlines from the Making Work Pay plan. So what I will do as a bit of an introduction for everybody is just outline in the document that Labour produced what their proposals are. And then I'm going to come to Lisa first and foremost in her capacity in a HR role to talk to you about some of the practicalities, and then no doubt Nick and Graham will both chip in with comments on these. So I think the big headline that it impacts absolutely every business, regardless of size, is the proposal for basic day one rights. So to read out Labour's I suppose theory behind looking at this, and I do think this will be one of the key highlights they push to drive forward. What they outlined was that the rate at which people move jobs has been declining, which is posing risk to productivity because of the lengthy wait for basic rights. That means the risk of moving job falls too heavily on the individual. So it's a problem for workers because those who switch jobs get pay rises on average 4 times higher than those who do not. It's also a problem for businesses because they may not be able to hire the best possible candidates. So Labour's changes would address genuine two-sided flexibility, giving workers the security to change jobs. So this would include basic individual rights from day one for all workers, which ends the current system that leave workers waiting up to 2 years to access basic rights for protection against unfair dismissal, parental leave and sick pay. And it would also, it wouldn't, should I say, prevent fair dismissals, which includes dismissals for capability, conduct, redundancy, or probationary periods with fair and transparent rules. It will ensure employers can operate probationary periods to assess new hires, but these changes are going to help to ensure newly hired workers are not fired without reason or cause, and hopefully that will aim at driving standards up in the workplace. So Lisa, I'm going to come to you just for your comment really on, in practice, what this is going to mean for businesses and how they can best plan for that.
Thanks, Sarah. So yeah, I just want to start by looking at kind of steps that you can take as these changes kind of loom in the forefront to how you can best prepare. So I would say, first of all, you need to be looking at what kind of current policies and practices you've got in place within your business. So that kind of 2-year safety buffer potentially won't be there anymore. So that probation period becomes really important. We need to make sure that we're maximising that time. So the first thing I'd be doing is looking at your contracts. Is your probationary period covered within your current contracts? Is the length of time that period is sufficient? So many people have between a 3 and 6 month. Now, it's not been decided, but they're saying there could be a limit on the probation period around the 6-month mark. So we need to make sure that we're really getting the most out of our workers in that beginning period. Within the probation period itself, I'd be looking at how you're reviewing performance, and that kind of goes right back to the basics. So I see your job descriptions being your foundation. So that's where I'd be starting, having a look at the current roles within your organisation. Do you have clear and concise job descriptions for each role? And is that communicated to the person that's within that role as well? If not, I would say that's kind of your starting block to get those in place. Also looking at the process throughout the probation period. So how are you reviewing that performance? We want to be making sure that we're having regular check-ins with our employees throughout that probation period, so they know exactly what's expected of them. You're reviewing their performance and kind of everybody's on the same page with that. Kind of aside from that as well, I would be looking at your managers within your business. So are they competent with addressing performance issues before they become a major issue? Are they confident in having these difficult conversations and using the process that you've got in place for probation periods effectively? If not, now's probably the time to kind of invest in some training towards them as well for that. We need to make sure that everybody's aware as well what the process is, how you're going to be measuring their performance. So looking at policies, if you don't have a policy in place, I'd be looking at implementing one, making sure that's fair and transparent so everybody's got sight of that, so we're all kind of working on the same page. The other thing that I'd be looking at is kind of current trends. So analysing data within your business, look at your turnover rates, average length of service. Are you conducting exit interviews with past employees? Can you pick out any key trends or anything like that as well? So the kind of key takeaways then from day one employment rights is really nailing down the processes within your business, making sure you train your management and being fair and transparent.
Perfect. Thank you, Lisa. Some great advice. Nick, from your perspective, obviously this will have a big impact on potential claims. So what's your take on the day one employment rights?
Well, yes, the reality is that with reducing the 2-year continuous service rule to almost to nothing, then we're almost bound to see a significant increase in employment tribunal claims, because it brings a lot more employees into that scope of people who might litigate. And of course, we don't know the full extent of this until we get some proper rules or regulations published. But looking at other countries who have a similar system in place, such as the Netherlands, and there are issues about the probationary period there, and I think what we need to see is whether or not staff agree to a probationary period, which should be fairly straightforward if they sign a contract of employment. But then, as Lisa talks about, there has to be some proper structure in place for dealing with matters during the probationary period. So I think what we'll ultimately see is that whilst it might be a day one right where you've got unfair dismissal protection. It may effectively be a 6 months type length of service issue if all that you need to do during the probationary period is follow the rules of an employer and just demonstrate that there are performance concerns. It may well be that it's not a particularly high hurdle to get over to show that there are issues for which an employer can dismiss an employee. Obviously, we'll just have to see. The other issue is, and I don't know if you touch on it later, but it's that the government is proposing to extend the period for bringing unfair dismissal claims from 3 months to 6 months. It's always been a bit of a short time scale for me, is 3 months, but 6 months might well just bring other people in into the frame, really. So ultimately, yeah, we're going to see an increase in claims, I'm sure.
Yeah, absolutely. And I think, you know, from an advice point of view, being a HR consultancy, you know, we often find not so much larger organisations, but certainly smaller businesses have very fluid probationary review. So some of that isn't maybe as well documented as it should be. There are, as Lisa mentioned, clear either job descriptions or performance reviews in that period. So I think that will become definitely an area of focus for everyone. So let's have a look at the next proposed change, which is around national minimum wage. So it's looking at the government's proposal really to introduce what they call a genuine living wage. So currently, as you may all be aware, minimum wage and then the living wage has got bandings. So in theory, an unskilled younger worker coming into the workforce, if a business is only paying minimum wage, is on a lower rate than others. However, what we're talking about is the removal of those bandings. So to give you the background from their proposals, the government commented that the national minimum wage, the creation of that, was one of the greatest achievements of the last Labour government, and as a result lifted many working people out of poverty and narrowed the pay gap between men and women, older and younger workers. The current Labour government would go further, and they're looking to make sure the minimum wage is a real living wage that people can live on. So to achieve this, they would change the Low Pay Commission's remit so that alongside median wages and economic conditions, the minimum wage would for the first time reflect the need for pay to take into account the cost of living. They would remove discriminatory age bands to ensure every adult worker benefits, and work with the single enforcement body in HMRC to make sure that they have the powers to ensure that that wage is properly enforced and that there are penalties for non-compliance. So Lisa, if I come back to you first and foremost, can you just kind of outline your thoughts on how this is going to impact businesses?
Yeah, thanks, Sarah. So obviously, with the potential increase of national minimum wage, bringing it all into one line, there's going to be considerable increases across business. So some of the factors to consider there is obviously how are you going to remain competitive within your current market, especially if you're providing a service or supplying goods. There's going to be increased costs for you to continue to run that, as well as having your increased costs with your staff rate wages. One of the key things to look at, as well as Sarah touched on, is there's going to be a lesser gap between your skilled workers and your non-skilled workers. So again, attracting that top talent to your business might become a real issue. So you need to have a look at your employer brand. So how are you remaining competitive to potential new hires? The main thing to consider as well with these increased costs is we don't want a drop in service. So we want to keep our customers happy. So how are you going to go about doing that? Ultimately, obviously, with increased costs, we don't have a never-ending pot of money. So it may come to a point when you need to look at your business. Again, I would be looking at each role individually, going back to the job descriptions, making sure we've got clear job descriptions for each role. Is your business kind of operating at optimum performance? Are people doing what's needed of them? Are you getting kind of the most from each worker? If we do have to look at maybe making cutbacks within a business, again, the other consideration to kind of bear in mind is that additional workload for the employees that are remaining. Stress and kind of burnout are one of the key areas that we need to be considering there as well.
Absolutely. And I think we've already seen in the last few years, as we've seen a real increase in the national minimum and living wage, that absolutely, it's not just businesses that employ minimum wage workers that will feel the impact of this. It proposes to be a real problem for businesses that will have more highly skilled workers that are paid a higher rate, because, like we said, that pay gap decreases. Graham, to bring you into the conversation this morning, welcome first of all, but from an accountancy point of view, are there any tips you could share with anyone viewing this of how they can start planning for potential increases to salaries?
Yeah, I think that there's a couple of main things just in the removal of the bandings, and I think Lisa touched on them earlier on. You're going to start squeezing your pay scales. So at the lower end, they're getting paid more. So then you have to look at adjusting your internal pay bands and moving them up. Do you need all the staff that you've got? Are you training for the future? I think the other piece around this just now is, it's really going to affect the proportion of the workforce under 21. So how many of them do you actually have in the business, or is this just not going to have a direct impact on you, but going to have a competitive impact when you're trying to hire new employees? And then it comes down to, do you have any mechanism for passing it on to your customers? Because ultimately, you can't take the extra hit and cost without trying to reflect that either in getting more productivity out of the business or passing it on to the end user ultimately.
Yeah, absolutely. So more than just a cost implication for us to think about, definitely around talent acquisition, and lots of feedback initially from businesses, certainly smaller businesses, that are suggesting that might put a halt to recruitment. So lots for us to think about on that front. So to move on to one of the next changes, flexible working, we've talked about to some degree in Nick's update, but combined with that, Labour, shall we say, leaked, or certainly it intimated that through the Telegraph and some other media outlets that part of the new package of employment rights may well be an opportunity for employees to have stronger rights to compress their hours to a 4-day week. Now, at this stage, it is very speculative about how that would look. The current government are suggesting that any proposal wouldn't force those demands on businesses. However, we honestly don't know at this stage what increasing employees' rights to request a 4-day working week would really impact. So, Lisa, again, over to you, just looking at potential ways businesses can plan around flexible working or the 4-day working week.
Thanks, Sarah. So again, as with kind of the other points that we've touched on, the first place that I would be starting is with your current policy. So reviewing your flexible working policy that you've got in use within your business. Is it fit for purpose? And also looking at your line managers again. So are they competent with the process and how it should be followed, the timelines and the deadlines for responding to requests? And also there are legitimate reasons that you can decline requests. So are they competent in kind of knowing and identifying what those reasons are? The other thing to consider is obviously, I'm sure everybody would love to work a 4-day week, but it isn't always practical. So have a look as a business, kind of what would that look for you? Is it something that you can accommodate without kind of lowering the service levels that you're providing or having an impact on productivity as well? Again, the main thing here there are some pros that could be had for this. So flexible working, I think COVID has a lot to answer for, especially when we look towards the 4-day week. So as a business, increased savings, it could help with retention and productivity. But kind of on the other hand as well, there are some cons that go with that. So it could also reduce your productivity, your profits. It could add stress on to employees who are trying to kind of work the extra hours within the 4 days or the longer days. So it's kind of swings and roundabouts. So I'd analyse kind of your business, how it's operating at the minute, and have a look at kind of what flex you've got within there.
Yeah, perfect. Nick, from covering flexible working and the changes we've already seen this year, is there anything to add, potential pitfalls for businesses if there is a greater requirement for them to consider condensed working, for example, as one of the areas?
Well, actually, advise on a few situations where employers have gone down to a 4-day working week. And there's two issues really. Firstly, as Lisa suggests, you need to look at the output here. Is how realistic is this? I think in the cases I've had, it was welcomed by staff simply because they increased. They did 4 days instead of 5, but a slightly increased working day. And the employer's main issue was whether or not there was sufficient coverage to deal with client queries, etc. So for all the parties it worked. But you might have a situation where all staff don't agree to it, because even though it sounds like it's nice to have a 4-day working week, if you actually got a longer working day, some staff might not be all that pleased at doing that. So then you've got the issue of changing terms and conditions, and seeking agreement, all those kind of things. And again, it starts with the contract of employment, doesn't it? What does the contract allow this employer to do? And if they are able to change working patterns, would it be reasonable to do that in the context of what the contract says? And if the contract doesn't allow this, then they're going to have to go through some kind of consultation process, really. And I think in most cases, if it's probably going to be one of two things. Firstly, there's a much longer working day, or a materially longer working day for people. How does that come across? And secondly, there might be a change in pay as well. If you're not working a longer working day, then your pay might be reduced. The employee might think there's some benefit to that, because the reduction might not be that significant. But there's plenty to think about. But I think it's all dealt with by way of consultation more than anything else.
Yeah, perfect. Thank you, Nick. Sarah, so looking at our next...
Sorry, Sarah, can I just jump in on the 4-day week?
You can.
We prior to being part of Northern Accountants, Northern Accountants acquired and powered by Cloud. We're a remote business and still remain remote. So we actually experimented with 4-day weeks before and had quite a big negative impact, mostly because we offered full flexibility. So it impacted on the flexible side that the team didn't want. And it also meant that we were struggling to, a lot of time was spent handing over to teams covering alternative Fridays. So maybe it was the way we introduced it. The team actually preferred to have more flexibility than almost the rigid 4-day week. So it didn't quite work out the way we were hoping when we piloted it last year.
Absolutely.
A lot to think about what team members physically want, whether they want more flexibility or a Friday off, for example.
Yeah, and hopefully we will get more clarification if the current government do move forward with that proposal, because at the moment, it is very limited. It's just a suggestion that this is going to be part of their agenda. So thank you all for that. Sick pay, a much more straightforward proposition out of the changes. Basically, currently, the government were looking to strengthen statutory sick pay, to remove the lower earnings limit to make it available to all workers, and also to remove the waiting period. Now, for businesses that operate perhaps not offering enhanced sick pay where it is only statutory sick pay, I can certainly see there would be the potential for an increase in absence if there are no waiting periods from the kind of cases that we deal with. So, Lisa, what's your take on this first and foremost? And then Graham, I might come to you to chip in on the impact financially to businesses.
Thanks, Sarah. So yeah, I think as with many of the points before, the first place I'd be looking at is your current absence policy. If this does come into play, then obviously that will need updating. So you'll have your employees who are entitled to SSP from day one without that kind of waiting period. Some of the impacts that you may have is you may find that absence levels within your business increase. You may have people, I like to call them, taking those ad hoc days here and there. Obviously, they're not having to wait to qualify for their sickness period. And I think those are the absences that have the most detrimental impact to your business. They're harder to cover, the last minute ones. So that's really what we want to be trying to stop. So we need to have a robust policy and a way of managing absence within the business. I would be looking kind of at your current processes, so analysing some data, having a look at what your absence levels are like. Are there currently issues? There are tools that we could use to help with this. So I would definitely be recommending, if you're not already, implementing return to work interviews. So a sit down with the line manager and the person that's returning from sickness, whether that's 24-hour period of sickness or a longer term absence, to conduct a return to work interview. This will help you kind of looking at trends and managing that absence as well. Another tool, if absence is an issue within your business, that could help is the Bradford Factor scoring. All of these are things that you can look to implement to hopefully reduce that absence level and keep it down. I would make sure that your absence policy is communicated across the business so all your employees are aware of kind of the reporting procedure and what happens in their period of absence. And also, again, we're going to go back to training. So train your management to handle absences. Are they competent and confident in return to work interviews?
Yeah, I think that is a big aspect, because much as we're talking about sick pay and the enhanced rights, you know, the flip side of this is that it's making sure from a welfare point of view, you know, the pro of having no waiting periods will be that those that might be genuinely too ill to work, that are actually currently working because financially they just can't afford a day of zero pay, you know, that they get some support. But I would agree wholeheartedly, Lisa. I think there is that element of welfare with our workers, and it's making sure that our managers in particular are equipped to deal with that, and that the policies make clear how the business will support people. Graham, are there any financial implications that businesses need to think about if statutory sick pay is payable from day one?
Yeah, I think, I mean, ultimately, a lot of it's coming down to what Lisa's saying. What are the trends? I mean, if there's a sudden switch that people are off sick more often because they're getting paid day one rather than having a waiting period, then I think you'd have to start looking at why they're taking time off. Is that an indication that there's something wrong within the business, something wrong within a particular department or a particular manager? So yes, there'll be a financial impact if people are getting paid from day one, but I think that's a minor part of the overall issue if people suddenly start taking sick days. There's, you know, we would manage trends and manage the individual rather than think this is going to be a massive impact onto the cost base.
Yeah, no, absolutely. So again, it's almost reiterating that importance of clarification of clear policies. And certainly some of the cases we handle with absence issues are often about a lack of confidence for managers or business owners in actually following through with those processes, or consistency in doing that. So certainly, again, that common theme and trend is around tightening up on those processes in the business. So looking at the next area, the right to switch off. So this definitely is an area of debate that, again, a COVID hangover, if you like, in that as we saw an increase, particularly in home working, then the temptation is that employees, you know, ultimately end up with a 24/7 office. And so to outline the government's take on this and what they're looking to more formalise with this is around the fact that hopefully good employers do understand that for workers to stay motivated and resilient, they need to be able to switch off, and that a culture of presenteeism is damaging to morale and productivity. Equally, workers know that there are circumstances where their employer may need to contact them, and some value the ability to work outside of conventional work patterns. So what they're looking to do is to bring in the right to switch off so that working from home doesn't result in homes turning into 24/7 offices. They'll follow similar models to those that are already in place in Ireland and Belgium, giving workers and employers the opportunity to have constructive conversations and work together on bespoke policies or contractual terms that will benefit both parties. So this is a big shift really in formalising what people might be doing as best practice at the minute. So I'll probably come to all three of you on this one, but Lisa, first and foremost, what's your take on the impact this is going to have?
Thanks, Sarah. So as you mentioned, I think COVID kind of really accelerated the flexible working, the home working, which has played a massive part in kind of blurring the lines between work time and switching off. It's really easy now if you think you've got an email to send, logging on while you're having kind of your dinner or just not getting that time to switch off. what I would be doing as a business is kind of reviewing what currently is your normal working practice. What do employees feel is needed from them? If your culture is one of those 24/7, keep going, look at steps that you can put in place to kind of reduce that, to allow employees to kind of take that time that they need to rest and recuperate. So whether that is introducing kind of regulations around kind of emails, not sending emails after a certain point or not having to respond before a certain time. I think it's a really good opportunity to engage with your workforce, get their kind of opinions on what the right to switch off looks like to them. Encourage the use of annual leave. Also looking at kind of, if somebody is taking annual leave, what's kind of going on with their workload in the background? Are they going to be coming back to 2 weeks worth of emails and a mountain of paperwork on their desk? So how are you going to redistribute that work so the employees that are switching off and getting that rest and recuperation that they need really are getting that, and they're coming back to work ready to go?
So I think, again, the implication here is around potential contractual or policy changes that are outlining that. So Nick, from that perspective, looking at how that might be done from a contractual point of view, how do you think that will impact? What plans do businesses have to start making to perhaps put these things into effect?
Well, I think one of the issues at the moment with this potential right is that we don't know how it's going to manifest itself in law. So we don't know if it's going to be a set of regulations, or, as perhaps more likely, it's going to be a code of practice. So therefore there wouldn't be a standalone employment tribunal claim if there's a breach of the code of practice, but it could result in an uplift in any tribunal award. So employers are going to have to start looking at their contracts for employment. As Lisa says, what is expected of the employee, what they're required to do. It seems to me that if somebody says, well, I don't have the right to switch off, I don't have to work beyond my normal working hours, then that's fine, isn't it? Expecting an employee to do more than that could then result in a breach of contract, potentially a fundamental breach of contract, loss of trust and confidence. It may give rise to things like constructive dismissal claims, where if an employer is forcing an employee to work beyond their normal working hours, effectively not having the right to switch off. It could involve discrimination claims if you've got childcare responsibilities. Is that then going to be sex discrimination? There's all kinds of issues that arise out of this, but it does depend on what this looks like in terms of whether it's going to be a form of regulation or whether it's going to be a code of practice, which I think it's going to be the latter. We'll just have to see what happens.
Yeah, absolutely. And Graham, you already mentioned previously that clearly first-hand experience, the business that you're in consists of home workers. You all work remotely. So what impact would this have? So from a business that's lived and breathed this, any advice you could offer?
Yeah, I think as you say, Sarah, we worked remote since pre-COVID and built the business remotely, people working from home and all the rest of it. And COVID certainly blurred the lines between when you're working and when you're not. We offered full flexibility, so that makes it even harder as well, because one person might want to work from lunchtime till 8 o'clock at night, and somebody might want to work 6 in the morning till whatever time during the day, just to fit in with their responsibility. So I think unless you've got kind of firm work hours, it becomes quite difficult to say when they can switch off. However, some of the things that we introduced was, yeah, it's fine if you want to work between 10 and midnight because it suits your agenda, but don't send the messages then. Don't send emails or whatever. Leave them to go during sort of normalized work hours. So there's some practical things that I think you can do to deal with that. We also, if we're sending messages out with normal hours, we don't expect the team to respond. If it's convenient for me to send at 8 o'clock at night, I don't expect the recipient to come back. So there's some policies you can put in place. I just wonder if it will start to reduce flexibility rather than enhance it, because bigger businesses will want to know that they're not stepping into this area. So they might reduce the amount of flexibility that's available to make it easier to manage. Potentially,
absolutely. And I think it's again from experience of of working with lots of businesses that might have a higher proportion of home workers, it's almost that education, especially for existing or new hires that come into the business, is understanding what the expectation is. Like you say, for example, that you may send an email at 8 o'clock at night without an expectation of somebody replying instantly. So I think, Lisa's advice then around outlining exactly what that looks like. And I think Nick also absolutely in agreement. It's probably more likely to look like a code of conduct. So we will have to see how that plays out. But I think good practice to be looking at regardless. So moving on to our next, which really is only going to have a big impact if you are mainly in the hospitality trade. There is obviously some changes that are around fair tips. So the big thing that this has been driven by is frontline workers in pubs, bars, cafes, restaurants, often would be on lower paid wages, and their tips and allocations of them is what can make a big difference to their take home. So Labour are looking to strengthen the law to ensure hospitality workers receive tips in full. But also a big shift is that the workers get to decide how tips are allocated. So Lisa, how does that impact businesses that are in the hospitality trade right now?
Thanks, Sarah. So yeah, as a business, the main thing is that you're fair and transparent. So as Sarah said, the employees will get a chance to kind of say how their tips are distributed. So I would use this as an opportunity to consult with your employees and together put together a policy that will be communicated to the business, kind of describing how tips are going to be distributed. I think one of the things to be clear with is it needs to be clear and transparent. The workers have the right to request to see how their tips have been distributed, and kind of breaching what your policy states or the rules does bring you a potential risk of a claim as well.
So Nick, the obviously the implication here is that it is a legal shift that the government is looking to have. So are there implications for those that don't follow the rules of allowing workers to obviously have a play in the decision, or might refuse to give information on how tips are allocated?
Well, again, we've not seen any regulations on this yet, but I would expect there to be, because I think one of the main issues here is that the government is signifying a move away from things like the trunk system for dealing with tips, which places some quite onerous responsibility on the employees themselves. But obviously, given that responsibility is now going to be with the individuals to agree where this money goes, and the employer is going to have some way of facilitating payment of this money anyway. They're going to be in some way responsible for it, or the handling of these monies. I think that's going to present some challenges. I think it's a bit of a watch this space on this one. I can see why the government might think it's a good idea leaving it to staff, but I think the machinations of it all might just cause some difficulties further down the line. Yeah,
no, absolutely. And our last area that we're going to look at on here, Nick, I'm going to come to you first actually this time, because you've already mentioned this when we were talking, which is around increased tribunal timeframes, so having longer potentially to put claims in. So what's your take on the difference that'll make to businesses?
It might not result in an increase or material increase in the number of claims, but I think given that, and obviously with the advent of ACAS being more involved in matters given the early conciliation, it may provide more scope for settlement of claims before a tribunal if the parties have longer to try and get something resolved. So I can see a positive impact there. The bigger problem, though, I think, is that because it's a longer time frame, employees and employers generally know where the land lies fairly early on. So, for example, if an employee is dismissed, most people go and get the job. We've all got bills to pay. That's the immediate thing to do. And in an unfair dismissal case, for example, there's no financial penalty to the employee. Compensation is essentially based on loss of earnings. So as soon as an employee gets another job, then the value of their claim diminishes. And of course, if they get a job with a similar rate of pay, often it's not financially viable. But the longer they're out of work, and then the less pressure on them to issue a claim quickly, it may mean that an employee has a better idea then of what their claim is worth. And therefore, if their claim might be worth a lot more, for example, then that places a bit more pressure on an employer to try and settle. If you get into 5 or 6 months since the dismissal, and the employee can demonstrate a much more material loss, then they're more likely to argue that any settlement at that stage should be higher as well, which works both ways. An employer might just think, oh, right, we'll have to pay more, or they might just think, well, actually, it's now too much. We're not going to settle for that. We'll see you in tribunal. But it could actually be counterproductive in some ways.
Absolutely. And Lisa, what's your take for businesses, in terms of from a day-to-day HR perspective, the fact that employees may have longer to claim? Are there any tips you can offer?
Yeah, so I think for me, the main one is making sure that you've got well-documented records. So if you're going through kind of any process with somebody, if we use kind of performance management as an example, you are documenting each stage on kind of what's been done and the actions taken, the support offered, making sure you keep them on file just in case in the future something does come about. You've got that to hand. Everything's documented, and it's just going to make it kind of easier for you in the long run, should you need to defend a claim. It kind of also goes back to what we've been saying throughout this as well, making sure your processes are robust, they are clear, your managers are trained on how to use the processes properly, and the policies are aligned with those processes and communicated across your business. Absolutely.
Well, thank you all for your take on some of the headlines. As I mentioned, the guidance that Labour issued is around 22 pages around proposed changes. We've just tried to pull out those that we think will have the biggest impact for the majority of businesses for this morning. One of the things that we are going to send out as a result of this will be a link where you can download some guidance we've put together that just talks about some of the key headlines and what that might mean for your business. So that does cover a few more areas. So we're now going to move on to Graham. So Graham Morrison, as you will have heard from his input so far, is part of the Northern Accountants Group, and so he's going to really put some perspective on some of the financial implications and taxation implications that the changing government might have in implementing some of these things. So Graham, again, I'm going to mute myself and hand over to you.
Thanks, Sarah, and hi everyone. So I guess one of the big things that the government's trying to do just now is plug a black hole and fund a lot of these new initiatives, push them through. Now, just to give you a bit of background, we're 30th September, a month away from the budget, and the government has announced that it has inherited the worst economy since the war. They've found a 22 billion black hole, which, to put into context, there was already a forecast 87 billion deficit due this current year. So it is significant. There is also a kind of habit of governments wanting to blame the previous lot and get all the bad news out early. But there is a significant financial hole, I guess, that's coming through, whatever the number is. Debt is now 100% of GDP, at just under 2.8 trillion. And just to put in, again, another bit of perspective, the UK government hasn't balanced its books since 2001. So it's run a deficit every year since 2001. So it's not unusual for it to be borrowing money and trying to become a bit more efficient. So what have previous governments done, before I go on and look at what Labour is maybe going to look at? So if we just pop on to a quick look back, every government that's come into power, or every change of party government, has always raised tax in the first budget. It's not unusual. 2010, we had an increase in corporate gains tax, capital gains tax, VAT, we had a bank levy. 97, we had a windfall tax on utilities. And if you go all the way back to the Thatcher government in 1979, although it's recognised as a tax-cutting government, it increased VAT, it increased CGT and everything else. So it's not unusual for a first budget from a new government to increase tax. But this one seems a little bit different because they have made a big push on not raising rates on the major taxes, so income tax, national insurance, corporation tax, and VAT. They've said in their manifesto that they're not going to increase the rates on those, and they're trying to promote growth. So with them saying a couple of months ago that it's going to get worse before it gets better, there's been an absolute whirlwind of speculation, leaks, what ifs, what might, and what comes out. And I think that's almost unheard of, and when I can remember that we're so far ahead of budget and so much speculation on what might happen because we know certain taxes are going to increase. So ultimately, there's probably three things that the government can do, or four, but one is they can cut spending, which won't reach their manifesto promise. They can expand the scope of existing taxes. So again, they're not increasing rates, or they can increase taxes out with the major ones. The other thing they could do is pretty much do nothing and hope the economy grows. And that naturally increases tax take as the economy grows. So if we just look at sorry, Sarah, if we could just hang on to that previous slide. So what cutting spending, we've all heard about the heating allowance. They've cancelled major projects and they're looking at department spend. If that's the route they go, there won't be big tax increases, so that should be okay for business. Expanding scope on existing taxes. So they've already announced VAT and private school fees. There's talk they might look at doing employer national insurance and pension contributions. So that could raise significant amounts. Adjusting allowances. So for example, inheritance tax has been spoken about as one place that they might look at, where you've got a £325,000 per person allowance. That could get reduced. They could hold on to the individual allowances just now and let people drag themselves into higher rates. Again, these could have impacts on certain businesses depending on what we decide to do. If they're freezing allowances, it's probably not going to have a significant impact on business. Increasing tax rates. They've already announced that they're going to increase the energy windfall tax or energy levy. It's now at 78%. The big one at the moment for business owners is probably capital gains tax. That looks as though that's going to get targeted, or there's a suggestion it's going to get targeted. So rumours abound that it might move from the current rates of between 10 and 28% to match income tax. So that could take pretty much double the capital gains tax, and is rumoured to increase tax take by about 16 billion. I think the main issue if they do that is, one, people will stop selling assets or try to sell them a bit earlier. If you're in the process of trying to sell a business or an asset, it's probably advisable to do it before the 30th of October, just in case. That also probably discourages, if you're getting taxed at 40-45%, selling businesses or people taking risk in businesses. So it doesn't quite, to me, marry up with the suggestion of trying to grow the economy. Increase in fuel duties have also been spoken about. So if you're in a haulage or logistics business, that could have quite a big impact on your running costs. And then there's a suggestion that there's maybe an introduced pay per mile charge on vehicles. This is probably to reflect the fact that electric vehicles are becoming more popular and aren't subject to road tax. So they're losing quite a bit of money through that. So some of these things could come in. So if we just pop on. So what could you do? Really depends where the burden falls and how much of it. As I said before, if you're selling assets, try to, whether that's a business or any sort of shares, try to do it before 30th of October, and you lock in the capital gains just now. One thing I would say is never do something just to avoid a tax. It has to go in within what you want to do overall within your business, and part of a strategic plan. Use ISA allowances or additional pension contributions go in just now before there's potential change to pension relief. I think the big thing on pensions, though, is I would only do it with surplus cash, because you're going to lock cash up for quite a while and to get it back out. So at the moment, it's a bit of a mystic meg. There's speculation almost every day about what other area is going to get hit and where it's going to go. But ultimately, they're trying to plug a hole. And whether they do that by increasing tax or whether they do it by incentives to try and grow the economy, it's a bit 50-50 at the moment, because it's said both. I think that's everything.
Thank you. And I think, like we've said, a lot of the employment issues we're covering today, a lot of the taxation issues, some of these is informed speculation, because we actually don't know at this point what is on the horizon. I'm just going to stop sharing on here so that we can just have a look at any questions that have been submitted to see if we've got any that need answering that haven't already been covered. So let's have a look at some of these, just to try and run through a few before we finish for the day. So we have got a question on here in relation to the right to switch off from Michelle. So the question being, and again, Lisa, Nick, Graham, all chip in with this. The right to switch off may have a big impact on service areas, i.e. if someone calls in sick and they're looking to cover a shift in a restaurant or in a shop, for example, there'll need to be policies or protocols for that, I would imagine. Does anybody have anything to offer advice for Michelle on that?
Well, I think ideally, irrespective of the right to switch off, there probably needs to be policies in place anyway dealing with that, requiring people to come in and give that cover if absolutely necessary. But I do see how it's going to be a balancing act, isn't it? Where, shall we say, there's an employer might exert some friendly pressure on an employee. Look, we need you to come in, that kind of thing. That kind of approach, it might well be, a bit close to the knuckle once these new regulations or code of practice comes into place. I think it's probably an industrial relations issue more than anything else, isn't it? If you keep your staff on side, they might be more willing to work when you really need them to.
Absolutely. And I think, Lisa, that is kind of in line with the advice you were giving, in that, again, we don't know how the right to switch off is going to be pushed forward by the government. If this is a code of conduct, then again, it's looking for that engagement with employees, isn't it? And setting out your clear policies so that you do have that ability. I mean, the outline that the government has put forward does incidentally say that, it is about outlining what that looks like and when the situations might arise where you do need to contact or engage with employees. So yeah. I guess, Lisa, that's going back to what you were saying around policy and outline.
Yeah, I think it's much bigger than that as well. So not just so much somebody's rang in sick, I'll have to ring somebody else and hopefully they'll come in, but it's having a look at kind of the culture within your workplace and fostering that loyalty amongst the staff and how you go about doing that. So actually they do want to come in and help you out if needed.
Yeah, no, absolutely. Now, I've got a couple of questions on here from Abby, so we'll maybe take the easier one first, then the others for you, Nick. So one of the questions is, when do we foresee the Labour changes coming in? Obviously, some of what Graham has been talking about, we've got the budget coming up, so we're going to be able to see what they're proposing in terms of some of the financial side. The elements relating to employment, then they did make a commitment that some of these changes we would see within 100 days of them being elected. My understanding, and actually this was also in a newsletter from you guys, Nick, was that we should start to see these plans being firmed up October time, but actually we don't have a definitive guideline at the minute as far as I can see.
No. I mean, all we're going to get really is an employment bill, essentially, which sets out what the law might well say when it comes in. But given the quite wide-reaching nature of these changes, I'd be amazed if there isn't some kind of further consultation before these things actually become law. So Well, we should have a fair idea what it might be, but I suspect there might be some tweaking or some changes, and it might just take a bit longer than October.
Absolutely. And I think the purpose of the webinar this morning as well was to just try and prepare people for what's to come, because there's been a lack of awareness of how big these proposals might impact business. So, if you are prepared and then, these things come into fruition and they are not as stringent, then that improves the situation for you as a business owner, rather than it being the other way around. So Abby's other question was directed at you, Nick, which was saying you keep mentioning about if it doesn't allow in the contract, you need to consult. But regardless of being in the contract, shouldn't we always consult if you want to change terms and conditions?
Well, if the contract allows you to change terms and conditions, then the starting point is no. But I think it's always got to be good to consult with staff about changes, because it is about engagement, isn't it? And if you're usually a change to terms and conditions is going to involve something which might not be immediately acceptable to staff. And the whole idea of consultation in these situations is really to explain to staff why this proposed change is necessary, that the employer isn't just doing it for the sake of it. There is a genuine business need for that. And my experience is that if employees are given that level of engagement and have the opportunity to say their piece, it's a bit easier for them to understand and then possibly accept the changes that are being proposed. Now, of course, if you don't need their agreement, then you don't have to seek it, do you? But I think all that happens then is you get unhappy staff, perhaps staff leaving, and as we know, employers have long-running difficulties in retaining good staff and then recruiting good replacements. So yeah, you're right. Even if there is no need to consult, then I'd always advise that you do so, because that's the best way to get these changes through.
Perfect. Hopefully that answers your question. We've also got a question from Laura that said, do we think ACAS are going to be expected to write a code of conduct or a code of around probationary periods? And I think the difficulty in answering some of these questions is we don't definitively know what this is going to look like yet, because these rights haven't come out, but ACAS are often involved where there are codes of practice to fulfill. So what's your take? So Nick, come to you first and foremost. Do you think it's likely that ACAS will be involved in setting out some of the guidance as it does in many other areas?
We will certainly see some ACAS guidance, I'm sure of that. Whether or not it's a code of practice, though, I'm not sure at this point. I think we might have a better idea whether that's going to happen once we start seeing claims filter through and what they're about, essentially. Once we understand fully what an employer is required to do during these probationary periods, as I say, we'll inevitably get some ACAS guidance, but a code of practice, I think, will only come, if it comes at all, once we know the specifics of what the regulations say on this.
Yeah. Absolutely. But I think, Lisa, you've mentioned when we were talking about day one rights, something that employers can do right now, which is, really good practice, regardless of day one rights coming in, is to formalise probationary period reviews anyway, because we do see lots of businesses that have such an informal process, and it almost feels like it's a gut feel rather than evidence driven. So Lisa, do you have any advice to offer Laura in answer to her question of what she can maybe do in the meantime?
Yeah, so I think, as I mentioned earlier, it is kind of down to the process that you're looking at. So I would definitely make sure you have a clear process, train your managers, and that it is being used. Regular check-ins. We don't want to be kind of having somebody that's starting with us and then sitting down with them at the 5-month point of their 6-month probation period to say, actually, you're not where we need you to be. It's so much easier to pick up poor performance or where there might be gaps earlier on, so we can work together with that employee and get them where they need to be.
Yeah, perfect. And there was one final question on here, then I think we've actually answered everybody's that was on, which was from Amanda, which is around unions, actually. So and this might be something we can follow up with you, Amanda, for a chat in a bit more detail. But what Amanda is in essence asking is, if they have employees in the business where there isn't a recognised union in a business and they are members of the union, would the unions step in to represent other staff, you know, even if there is a cost to that? I'm assuming where you're thinking that there might be some group action that's there. So, you know, does anybody have some advice for Amanda in terms of union representation? I mean, if it's not a recognised union within the company anyway, that usually is individual membership.
Yeah, that's right, Sarah. If it's not recognised, if the union isn't recognised by the employer, then the union's involvement is limited really to the legal situation in which they can attend or assist staff. So essentially, that's going to be disciplinary and grievance hearings where they can accompany staff. And the important thing to remember there is, you're entitled to be accompanied to such a hearing by a companion, sorry, not a companion, a colleague, so somebody who works for the same employer, or a trade union representative. Don't necessarily have to be a member of that trade union. And then the only other situation where a union may be involved is possibly in things like you know, where there's collective consultation, if for some reason they're voted in, but unless they're recognised, their involvement can be quite small. What is likely to happen though under Labour is that that they're already talking about, a part of the general message that Labour's putting out is that they're going to try and make it easier for unions to be involved in workplaces. So there's a less prescriptive approach to things like recognition, where they don't need to reach certain percentages of the workforce before a union can apply to be recognised, and they'll allow unions to easier channels of communication with employers which obviously in the hope that they'll get more people signed up to unions. So I think that's likely to be a big issue, because you will find more smaller employers then, perhaps with more union presence than they've ever had. Because typically most small employers don't have a union presence at all, but that might actually change over time.
Perfect. Well, thank you all. So just before we wrap up, because there's no other questions awaiting answer that I can see, for everyone that's attended, just to let you know, there will be a follow-up email that will come out that will give you access to three things essentially. One will be the recording of today's session. Please do feel free to share that with colleagues or contacts. More than happy for them to have a watch of what we discussed today. The second will be, as I mentioned earlier, there is a ultimate guide we have put together. We will send you a link if you want to download the guide that covers certainly the headlines we've talked about today, plus a few more. And the third thing will be the contact details for all three of our experts today. So for Lisa, Nick and Graham will be on there. So if you'd like to approach them directly to follow up or for any guidance or advice, then please feel free to reach out and do so. I think on that note, the last thing for me to do is just to thank Lisa, Nick and Graham for attending this morning and sharing your opinions on this. Happy if anybody has any questions that they've not submitted, please do just reach out to us and we'll aim to answer those for you. But on that note, we will wrap up for this morning. Thank you all for attending.